Lords, I appear on behalf of the appellant, Ms. Jhuti, and I have with me Mr. Matthew Jackson, representing the respondents are Simon Gorton QC and his junior Jack Mitchell. Can I start with an apology? You will have seen that the bundles were in late. We have principal responsibility for the carriage of that exercise. We didn't hit the time limit. We are sincerely sorry for any inconvenience to which that has put this court.
Worse things happen at sea.
Very grateful, my lady. In preparing this case, I've had a rather unnerving experience, which is the more I looked at it, the more straightforward the question seemed to become. That's usually a bad sign, and I may be about very wrong. It seems to me that the issue that you have to consider today is capable of being distilled quite simply. What we're really asking you is, when determining the employer's reason for dismissal, in the context of the unfair dismissal legislation, is it ever permissible to look beyond the mind of the specific decision maker? That's what's been identified as the attribution question. We think, for our part, that the attribution answer, to coin a phrase, is ultimately, indeed immediately, a question of policy. And that the policy that you'll have to consider has two aspects. One, we stress, the other, the respondents stress. We stress that this is an act which has a plain protective purpose. And that if that protection is too easily defeated, the policy underpinning the act will be frustrated. The respondents say, in essence, and I hope I don't do their submissions an injustice, if you chase too readily after achieving that purpose, you may end up placing the respondents, employers generally, under impossible burdens practically. So that those two factors have to be brought into a balance, and the question is whether the balance as presently struck is right. So in addressing the issue on behalf of the appellants, what I propose to do is take you through 5 stages of argument. The first stage is something of a roadmap. What I hope to do is to introduce the issues and the principal legislative provisions by means of walking through what amounts to a simplified version of the facts in this case. So I can show you at which point which provisions are engaged, and in relation to each provision, how attribution is dealt with. Once I've done that, I hope to move to reiterate in short summary how we say the question should be answered, how the attribution question should be answered in the light of that walkthrough. I'll then, at the third stage, turn to the case law, and I hope to reassure you I don't have much case law to refer to, so that we've got a lot in the bundle, undoubtedly, but we'll be looking for our part at one case on attribution generally, very quickly at 2 cases in relation to what reason means in the context of unfair dismissal, and then 2 cases on attribution within the employment context specifically, one Orr and Milton Keynes, which is obviously of very great significance in this case, and the other, the decision in this case below in the Court of Appeal. I'll then touch on what we think the highlights of the arguments against our proposed approach are, and try.
Is this point 4?
This is point 4. Although I'll try not to, as it were, give a full reply before my time is due. And then finally, there's an issue about disposal, which I hope to address you on. And again, I hope that will not take very much time. So with your permission, if I could move to the first of those tasks, the walk through the simplified facts. There are really 4 principal stages in the factual background. You might see them as 4 occasions in which there's an interaction between the claimant and her employer, and 4 occasions on which attribution is going to be relevant. Those 4 stages are, first, the claimant making protected disclosures. The second is the claimant being subjected to detriments. The third is the claimant's performance being investigated. And the fourth is the dismissal itself. So starting with the first of those matters, there's no dispute that in this case the claimant made protected disclosures for the purposes of the Employment Rights Act 1996. And I'll come in a moment, if I may, to the specific provisions of the 96 Act which set out the scheme. In particular, the tribunal found that there were, as it were, two sets of disclosures. The first were protected disclosures, and these are the ones critical for this appeal, made to her line manager, Mr. Widmer. They were made in two emails, one dated the 8th of November 2013. There were two emails on the 8th of November 2013, to be wholly accurate, and a further email on the 12th of November 2013. And those are dealt with in paragraphs 278 to 287 of the Employment Tribunal's decision, unless you specifically want me to take you to those factual findings. I don't at present propose to do so.
But it's not controversial, is it?
It's uncontroversial, as I understand it. And then a second set of protected disclosures made to a Ms. Rock, who worked in human resources, on the 10th of February 2014, and those will be less significant for the purposes of our argument today. So can I keep the promise and take you to some legislation? We're going, please, to section 43A of the Employment Rights Act. That's at MS 467, which, if you're using paper bundles, is in the first bundle of authorities behind tab 6. So here we are at the start of Part 4A, Protected Disclosures. 43A, the meaning of protected disclosures. In this Act, a protected disclosure means a qualifying disclosure, as defined by Section 43B, which is made by a worker in accordance with any of Sections 43C to 43H. And 43C is going to be the important one from our point of view. So it's quite unusually structured as a protection, but what it does is deal with two separate issues. You're a qualifying disclosure, very broadly, if the disclosure involves disclosure of information which tends to show one of a number of consequences, the most common being that someone has acted in breach of the law. But in order to be a protected disclosure, what is important is who that disclosure is made to. I said for present purposes, the relevant clause is 43C, which you'll find at MS 480. So at 43C1, you'll find it says a qualifying disclosure is made in accordance with this section, inserting some square brackets, and therefore amounts to a protected disclosure, if the worker makes the disclosure A to his employer. So in this case, when Miss Jhuti made the protected disclosure to Mr. Widmer, or the protected disclosures to Mr. Widmer, she was making them to her employer for purposes of the statutory scheme dealing with protected disclosures. In other words, at this stage, there is a statutory attribution. At this stage, when Mr. Widmer is hearing the protected disclosures or reading the protected disclosures, he is the employer for the purposes of the Act. So what Mr. Widmer reads, the Royal Mail reads. Mr. Widmer knows, the Royal Mail knows. So we come to the second stage of our journey through the simplified facts. The claimant is then subjected to detriments. So I suspect grossly oversimplifying, Mr. Widmer effectively then confects performance concerns about the claimant. And perhaps I will at this point please take you to the judgment itself and invite you to turn to MS 231, which is in the core bundle. In the last section. To paragraph 300. So the Employment Tribunal is dealing there with the first of two allegations of detriment which they uphold. You'll see the allegations set out in the subheading above paragraph 299 at MS 230. It says, being bullied, harassed and intimidated by Mike Widmer, who imposed mandatory weekly one-to-one meetings and targets solely on the claimant. At 300, the tribunal finds, furthermore, we find that this action and other actions in connection with it did amount to bullying, harassment and intimidation by Mr. Widmer. From our findings regarding the meeting the 13th of November 2013, we do not consider that Mr. Widmer genuinely held any serious performance concerns at all about the claimant. So remember that this is a case in which it is ultimately dismissed for poor performance. The person who at that point had deputed responsibility for assessing her performance on an ongoing basis, her line manager, had no genuine concerns about her performance, but was acting as if he did. So we'll see that the second detriment to which she is subjected is that which you'll find in the subheading above paragraph 309, which is at MS 232, being served with a document entitled Performance Plan Objectives by Mike Widmer, and informed that it was a condition of her passing her probation to complete this and provide all her key contacts from her previous employments in the travel sector. So again, their view is that there were no serious concerns about performance, and you'll see that at paragraph 310 at 233, MS 233. This was a continuing form of detrimental treatment to the claimant, continuing from the treatment referred to in the section above. As we have found, there were no serious concerns about her performance, and these were just further steps on the path of setting her up to fail. Now, I invite you just to notice that language because it's going to be important for the way in which we go on to put the case. Her line manager is creating a situation in which he is setting up an employee to fail. And as we'll see, the reason why the tribunal concludes he does that is because of the protected disclosures. So looking at that issue, if I can ask you just to flick back to MS 232, paragraph 306, which is dealing with the first detriment. They say in the first sentence, by contrast, we do consider that the overriding reason for this treatment...
I'm sorry, which paragraph is that?
Lady, it's 306.
306, thank you.
We do consider that the overriding reason for this treatment was the protected disclosures which the claimant made on the 8th and 12th of November 2013. And in relation to the second detriment, the performance plan objectives, and making a condition that she provide all her key contacts, the tribunal finds at 311, paragraph 311 at MS 233, as to the reason for this treatment, we repeat the findings in the section above and find that the overriding reason for the protected disclosures, which the claimant made on the 8th and 12th of November, were the protected disclosures which the claimant made on the 8th and 12th of November 2013. That word overriding is going to be important again to how we put this case, because you'll be aware, I hope, that in a pure detriment case, the question of the importance of the prohibited factor is dealt with in a way which is analogous to a discrimination case. So let me spell out what that means. It simply means that if the protected disclosure forms any material part of the motivation of the employer in subjecting the employee to a detriment, that is enough. That is to be contrasted, as we'll see, with the approach that is taken in relation to dismissal cases in section 103A, which I'll take you to shortly. You're looking for the reason or the principal reason. So to put it in layman's terms, it's not enough that a dismissal decision is tainted by a protected disclosure. The protected disclosure has to be the reason or the principal reason for it. And that's why we say this finding of the protected disclosures being the overriding reason for the detriment is important, because it's another way of saying, we say, that for the purposes of subjecting the claimant to a detriment, the reason why it happened, or the principal reason why it happened, was the protected disclosures. And without wanting to, as it were, tease you, that's going to be important when we come to the question as to whether or not, if you find in our favour, you're going to create an unruly horse which will trample its way across the law of unfair dismissal more generally. So we need to look very briefly at the provisions which relate to detriment to look at how attribution is dealt with there. And we'll find that at section 47B, that's at MS 552. you're using the physical bundle, it's tab 6. So we're really interested in 47B1. A worker has a right not to be subjected to any detriment by any act or any deliberate failure to act by his employer done on the ground that the worker has made a protected disclosure. So under subsection 1, an employer can be directly responsible for subjecting an employee to a detriment. And of course, in a case where you're dealing with a corporate employer, there will be a flesh and blood individual who has subjected the employee to the detriment, and it will be their acts and their motivation which is attributed to the employer. So again, there's an attribution issue here in 47B. If what you are faced with is an act or a motivation in an employee who is not someone who is capable of giving rise to an attribution to the employer, that case will fall under section 1A or subsection 1A, which is a section added, as we'll see, sometime after the Act was brought into force, in fact in 2013, in order to deal with vicarious liability cases. So there are two different ways in which an employer can end up liable for an employee being subjected to an act of detriment. It may be treated as their act through the attribution principle at 47B1, or they may find themselves vicariously liable for a detriment as a result of the application of 47B1A. But focusing on 47B1, which is what the tribunal did, it's the only provision they cite in their summary of the law, we'll see that Mr. Widmer's actions were treated no doubt because he was the line manager, he was the person responsible for assessing performance, for introducing performance improvement measures if necessary. That was treated as the employer's act. So this is a case in which the claimant has succeeded under section 47B. So just summarising, so far, as we walk through these facts and look at the attribution issues, it is as a matter of law the employer to whom the disclosure has been made, and it is the employer that has subjected her to detriments. Specifically, to adopt the language that the tribunal uses, the employer has set her up to fail. The employer has no genuine concern about her performance. But the employer has set her up to fail in performance terms. And just by way of an aside, we know that there are findings of detriment relating to Ms. Rock in the HR department. She made 2 offers to the claimant to leave the respondent's employment, one in return for 3 months' pay, one in return for a year's salary, and both of those interactions were found to amount to detriments. So again, by way of aside, the employer at the same time is seeking to persuade the claimant to leave their employment. So we come to the third stage, the claimant being subjected to a performance investigation. So the claimant was a probationer, and the employer, the Royal Mail, needed to be satisfied that she had met the necessary performance standards. We know that in ordinary circumstances, that would have fallen to Mr. Widmer to decide. And it's, I suppose, technically speculation, but it seems a pretty safe bet that had it been left to him, since he was setting her up to fail, what the outcome would have been, but she objected to his involvement, and Miss Vickers was appointed to review performance. So what she decided at the end of her review was that the claimant had not met the required standard, despite being issued with a 5-point improvement plan. And now you'll recall that being issued with a 5-point improvement plan was itself an act of detriment. So that's the context within which she makes a decision. But 2 points I can make quickly, I hope, from the statement of facts and issues in relation to what's happening here. First, if I can invite you, please, to turn to MS 50 in the core bundle, behind the statement of facts and issues tab, and to look at paragraph 27.
27 of what, sorry?
Sorry, we're in the core bundle, Statement of Facts and Issues, paragraph 27 at MS 50. The task she had, Miss Pauline Vickers, the head of sales operation, who had no previous involvement with the claimant, was appointed to consider whether or not to dismiss Ms. Jhuti. So she is going to be the ultimate decision maker in relation to dismissal, and the issue she has to decide ultimately proves to be whether or not the claimant's performance has met the required standard. And we can see that from paragraph 31 in the Statement of Facts and Issues at MS 51. Ms. Vickers accepted Mr. Widmer's account, and by letter of the 21st of July 2014, she dismissed the claimant with 3 months' notice, having found that over the period 28th of November to 3rd of March, the claimant did not meet the required standard, despite being issued with a specific 5-point improvement plan. Ms. Vickers dismissed the claimant, having formed the view that it was unlikely the claimant would achieve the standards expected in the role. This was a genuine belief on Ms. Vickers' part. So we say it's important to understand the process which is going on here. Quite a lot of the submissions that you're going to hear from the respondents approach the issues you have to determine as if all cases are effectively misconduct cases, that they are cases which involve formal investigations. But there are many ways in which an employee can end up having their employment terminated by an employer. And in each of those different routes, there are different expectations about the process which must be followed in order for there to be fairness. And one would expect, and one discovers, that on the ground they differ in how they are put into place. So in this case, in a performance case, there is, of course, a line manager whose principal responsibility is to monitor performance, identify whether improvement is necessary, and in most cases, to go on to decide whether or not probation has been successfully completed. This case is unusual in that Ms. Vickers was injected, as it were, into the process. But what we say is significant, and we'll ultimately try and persuade you as a point missed in the Court of Appeal below, is that no one was expecting that Ms. Vickers would herself perform any assessment or any direct assessment of the performance of the claimant. So she was not going to watch the claimant at work, supervise her for a period, set her targets and see if she could meet them. All she was able to do, and all she was ever going to be able to do, was to review the material that Mr. Widmer had put together. Material he had put together in circumstances where the tribunal had found that he was not doing it honestly because he didn't have a genuine concern about her performance, and that he was setting her up to fail. As we'll see, the tribunal goes on to hold at paragraph 346 of their decision, and if you're still at MS 51, you'll see that that finding is set out at paragraph 33. That made dismissal inevitable in the tribunal's view. However independent Ms. Vickers might have been, however well disposed to the claimant she might have been, there was really no other possible outcome in those circumstances, because the determinative cause of the dismissal, the determinative cause of the decision to dismiss, was what Mr. Widmer had produced. So we say it's important, and we'll have to come back to this in rather more detail, for which forgive me, it's important to bear in mind when deciding the attribution question that in many, indeed we say probably most cases of this sort, you're not going to find a decision maker who is the sole arbiter of the process.
She was not a puppet. She was not a puppet. She was making an independent decision. She asked what was going on in these emails. So she was exercising some judgment of her own.
Yes, so we don't say of Miss Vickers that she shared any adverse motivation. And the tribunal makes the finding, the very clear finding, which I think I've taken to you already, that her reasons was a genuine belief in poor performance. I'll come to say in a moment why I say that's not going to be enough. as it were, to get or shouldn't be enough to get the respondent off the hook. But just to complete this stage, she, of course, acts on the behalf of the employer in carrying out her part of this process. Mr. Widmer acts as the employer in carrying out his part of the process. And so I'll come, when we come to proposing the solution, as to explain why we say that is of particular significance.
So are you really saying that there was a decision made by two employees in this case? You seem to have come quite close to that
Yes.
in your last remark.
And I understand why you would think I'm coming close to that. I suppose I am coming close to it, but I'm not saying that.
You're not saying that.
So there is a decision, but it's a decision which is the culmination of a process in which more than one individual is involved. And it's a decision which can't simply be divorced from that process. So you'll have seen that one of the proposed situations in which we say you may need to look a little wider than what's in the mind of the immediate decision maker is what we've described as a corrupted process case, where someone is doing their honest best to make a decision in good faith, but the process has already been corrupted, and that process is corrupted by someone who counts as the employer. So that when you're saying, what's the employer's reason, you're not simply saying, what is the decision maker's reason? You're saying, what is the employer's reason for termination? That we say would naturally encompass not just the ultimate decision maker, but anyone who, as a result of an involvement in that process, has a determinative effect on the decision. So we certainly don't suggest that Ms. Vickers is acting in any way in bad faith, but we urge upon this court what the tribunal found, which is effectively, however open-mindedly she approached the question, the outcome was inevitable. The reason why the outcome was inevitable was because of the bad things, as it were, that Mr. Widmer had done. Now, I want to pause in the journey just before we reach the final stage to take you down a side road, if I may, for a moment, which is constructive dismissal. So just pausing in our story, at this point, Mr. Widmer, and for the purposes of section 47B1, her employer, has bullied and harassed her, put her on a performance improvement plan, even though there were no genuine concerns about her performance. And again, to quote the tribunal, set her up to fail in circumstances where, because she was on probation, if she failed, that would result in termination. Each of those things have been found to be an unlawful detriment. And we say there can't be any real doubt in those circumstances that because those are treated as being the employer's actions, in section 47B1, she would be entitled at that point to say, you've breached the implied duty of trust and confidence, I've had enough. You can't expect me reasonably to have trust and confidence in an employer who is deliberately setting me up to fail and manufacturing performance concerns. If she had resigned at that point, what would the legal consequences have been? And for that, we need to go first, please, to MS 591, which is in the first bundle of authorities. We're going back to the Employment Rights Act 1996, to section 95(1)(c). Section 95 deals with the circumstances in which an employee is dismissed. And at 1, it says, for the purposes of this part, an employee is dismissed by his employer, and subject to subsection 2, only if, and then if we come down to C, the employee terminates the contract under which he is employed with or without notice, in circumstances in which he is entitled to terminate it without notice by reason of the employer's conduct. So if at this point, as Jhuti had said, that's enough, I'm leaving, she would, we say, have been treated as dismissed under section 95 of the Employment Rights Act, and of course dismissed by her employer under 95(1). The next question would be, would the reason for the dismissal in those circumstances be the protected disclosure? And we say the answer to that is yes, and that arises as a result of the operation of the principle set out in the Berryman and Delabole case. You'll find that at MS 1001. It's in the third authorities bundle behind tab 19. And what's being addressed here is the, on the face of it, difficult question. How do you decide what an employer's reason for dismissal is where the employer hasn't dismissed? Where the employee has instead resigned? And that's picked up by the Court of Appeal at MS 1005 at H and the following paragraphs. And with your permission, I'll read those to you now. What says, first, in our judgment, even in a case of constructive dismissal, Section 57(1) of the Act of 1978, which was the predecessor provisions to the present provisions, imposes on the employers the burden of showing the reason for dismissal, notwithstanding that it was the employee, not the employers, who actually decided to terminate the contract of employment. So even though there's a resignation, it's still the employer's burden to show the reason for termination. In our judgment, the only way in which the statutory requirements of the Act of 1978 can be made to fit a case of constructive dismissal is to read Section 57(1) as requiring the employers to show the reasons for their conduct which entitled the employee to terminate the contract, thereby giving rise to a deemed dismissal by the employers. We go on to say in the next paragraph, if that is right, when one turns to Regulation 8.2 and asks the question, what was the reason or principal reason for dismissing the employee? In a case of constructive dismissal, attention has to be focused on the employer's reasons for presenting the employee with the ultimatum, changing his guaranteed rates of pay, which was the issue in that case. The employer's reasons for the conduct, for their conduct, not the employer's reaction to the conduct, which is important. In the present case, the reason for the employer's ultimatum was to produce standard rates of pay, not in any way to reduce the number in their workforce. So in this case, had the claimant resigned, the question facing the tribunal would have been, what was the reason for Mr. Widmer's actions? And was the reason or the principal reason the protected disclosures? And we know that the answer to that question would have been, yes, it was, because the tribunal found that the overriding reason for Mr. Widmer's conduct, thus for the employer's conduct, under Section 47(b)(1), was the making of the protected disclosures. Now, if that's right, what's the consequence? Well, for that, we need to go back, please, to the Employment Rights Act, to Section 103A, which you will find at MS 634, behind tab 6 in the first bundle of authorities. So an employee who is dismissed shall be regarded for the purpose of this part as unfairly dismissed if the reason, or if more than one, the principal reason for the dismissal is that the employee made a protected disclosure. So in a constructive dismissal situation, in this case, what would have happened is the tribunal would have said, you're entitled to resign. Why are you entitled to resign? The conduct. That means that there's a dismissal under Section 95. What was the reason for that conduct? Well, we found the overriding reason was the protected disclosure. So if the reason for the conduct is the reason for the dismissal, then the reason for the dismissal is, in an overriding sense, the making of a protected disclosure. So at that point, the claimant would have fallen squarely and incontestably within the scope of 103A, and would have been entitled to bring both, if she wanted to, a detriment claim in relation to the specific detriments, but also an unfair dismissal claim in relation to the dismissal itself. And that would have had a series of consequences for her in terms of the availability of certain remedies, the availability of interim relief, for instance, and re-employment remedies, which I will come to again shortly to explain what they are and why they're available. And we say it's a very odd situation, or would be a very odd situation, If she could bring herself comfortably within section 103A and win an unfair dismissal case, essentially at a trot in circumstances where she hasn't been dismissed. But if she is dismissed as the inevitable consequence of Mr. Widmer's protected disclosure motivated acts of detriment, that she has no claim in section 103A. So we accept as a matter of principle that constructive dismissal cases and express dismissal cases may raise different issues in different cases, but we say this really does cry out as an extraordinary result. If she is bound to win, if she resigns, bound to win a dismissal claim if she resigns, but bound to fail if she's dismissed. And I'll try and help you, as it were, square that circle moving forward. We come to the last stage on the journey, which is the dismissal. And that's where the finding that was made at paragraph 346 of the tribunal's decision is, we say, most important. And perhaps I can ask you just to have another look at it. You'll find it at MS 240 in the core bundle. No, you won't. You will find it. Sorry, happening. Oh, yes, it is. It's at MS 240, forgive me, 346. You'll see the tribunal's very helpfully underlined it. They say, however, given Mr. Widmer's actions, including the treatment which he meted out to the claimant as a result of her protected disclosures, the email trail that he prepared in this context being the investigation, and his other actions as set out in these reasons above, it was inevitable that Miss Vickers would, as she did, dismiss the claimant. So just pausing there, if we run through the attribution issues to date, before taking the section 103A attribution issue directly, as a result of the various statutory provisions, the claimant has made a disclosure to her employer. The attribution test at that point says when she speaks to Mr. Widmer, she's speaking to her employer about the protected disclosures. The employer has set out to determine, has set her up to fail. That's the consequence of the attribution test in 47B1. The employer has then set out to determine whether or not she has failed, having set her up to fail. The employer, again in the person of Mr. Widmer, has made dismissal inevitable. And the employer, in the person of Ms. Vickers, has decided to terminate the claimant's employment. So we say in those circumstances, if you ask the question, what was the employer's reason for termination? To say we will now only ask ourselves what was in Ms. Vickers' mind, divorcing that question from what one might call the attribution context of every other previous stage of that process would be artificial. We say it's both contribute to that process, Mr. Widmer and Mr. Vickers. Both are acting as agents of the employer when they do so. And it would be artificial then to say we will now only look in Mrs. Vickers' head. Now that takes me to the end of that journey and to the start of the proposed answers. So in what circumstances, or how, actually I should put it more clearly than that, how does attribution work? How should attribution work, we say, in a dismissal case under section 103A? We've seen, I hope, in our case that we say that there are three different sets of circumstances in which this might be an issue. And I should say, to give credit to Lord Justice Underhill, that to a considerable extent we have cribbed his work. So, and I'll need to take you to what he has to say in this case below. But we've labelled them, I hope helpfully, as the simplest case, what we call a corrupted process case, and a setup case. And I should say that what we have to say on the setup case has narrowed from what we have had to say in the case we put before you in writing. So we felt braver when we wrote that than we do now, and I will explain in a moment how we have narrowed the task. So far as the simplest case is concerned, imagine a case in which Ms. Vickers had, as it were, descended into the issue and said, well, what I need to decide is whether or not you have been properly performing. There's an issue I see as to whether I can trust what Mr. Widmer has to say, because you've raised a grievance about that issue, albeit that I've been told I must not look into it. I will now set about deciding whether or not your performance was up to scratch by looking, as it were, objectively at what you were doing. So I'll go round or through or over Mr. Widmer and form my own assessment of what happened. You can see in those circumstances that Mr. Widmer's influence is removed entirely, and there really is only one person materially involved in the decision-making process, and that would be Ms. Vickers, the decision-maker. Equally, one could see that if Ms. Vickers had not been involved, and it had simply been left to Mr. Widmer, as it ordinarily would be, to decide whether or not the claimant had successfully completed probation, that his would be the only mind that one looked to, because he had performed all of the assessments to date, and he would be the person taking the only decision. The case run by the respondent is effectively based on Orr and Milton Keynes, and I'll come to say why I think that is wrong in a second, is that's all you ever do. The simplest case is the only case that can meaningfully be reached by way of an outcome in circumstances where you're dealing with attribution. We're going to say that in relation to our other two proposed approaches, that they either fall outside the ratio of Orr, and that there are good reasons for saying that attribution should be dealt with in the way in which we proposed, or if they fall within the ratio of Orr, that ratio needs to be reassessed for the reason that it omits, we think, one critical point, which is the reasoning of the majority in Orr proceeds on the basis that the employer, widely defined for present purposes, intends to get to the truth. So can I start with what we've called the corrupted process case and take you first to the ratio in Orr and Milton Keynes, so I can put that in its proper context. The Orr case you'll find starts at MS 1120.
Sorry, I didn't hear that.
It's MS 1120, lady. That's in Authorities Bundle 3 at tab 28. And when I reach the section of the submissions where we deal with case law, I'll go into this in a little, I hope not very much more detail. But if I can take you, please, to paragraph 58 of Lord Justice Morbick's judgment, which you'll find at MS 1137. You'll see in the last part of paragraph 58 at G, he says, the answer to the question, whose knowledge or state of mind was for this purpose intended to count as the knowledge or state of mind of the employer, will be the person who is deputed to carry out the employer's functions under section 98. And that was a proposition with which Lord Justice Aikins agreed in paragraph 86 of the judgment, which is at MS 1145, and which Lord Justice Underhill, in this case below, described as the essential ratio of Orr. So the first point that we want to make about this is that one should be careful not to read what is being said here too narrowly. The first reason for that is when they talk about the person who was deputed to carry out the employer's functions under section 98, there may be more than one person to whom the functions are deputed. Because as I've described, the process need not consist solely of the single point of making of the decision, but it will involve necessarily the investigation, the collation of the material, the production of the material necessary for the making of that decision. So we say it would be dangerous to assume that when one is dealing with the deputing of the employer's functions under Section 98, that one always has in mind a single individual. The second reason we say there needs to be care is, as we'll see when we look at the judgment in a little more detail, the concern about the practicability of a wider approach to the imputing of knowledge and motives to an employer that runs through the judgment of Lord Justice Moore-Bick in this case is premised on the notion that it would be unfair, as it were, for an employer who is investigating in good faith, to find that their good faith conclusion is derailed by information they couldn't reasonably have come across in the course of their investigation. And that's a point that I want to take head on in a moment. Those are our two concerns. If we start with the question of more than one person, may I invite you, please, to take up, if you're using the paper bundle, the fourth authorities bundle, and turn to tab 42. It's MS 1437. We're looking at the ACAS Code of Practice. And in particular, if I can invite you then to turn to MS 1445. You should, I hope, see a heading Discipline, Keys to Handling Disciplinary Issues in the Workforce. Just pausing there, I stress again, not every case is a discipline case. But focusing for the moment on discipline cases, you'll see at paragraph 6, the guidance given by ACAS is, in misconduct cases, where practicable, different people should carry out the investigation and the disciplinary hearing. Those two different people would both be people who had deputed to them employers' functions under Section 98. Just to take an example, what we say would be a corrupted process case. Imagine that the investigation has been deputed to a learned friend, Mr. Jackson, and the decision has been deputed to me. Mr. Jackson, being corrupt and motivated by a protected disclosure made by the employee, simply invents a case. Doesn't interview the people he should interview, pretends he has, makes up their evidence, constructs from the ground up a series of untruths, which he then presents to me. The employee says, well, none of this is true. I say, well, this has been very carefully investigated by someone who's acting on behalf of the employer. They will reach the conclusion that these are the facts. In those circumstances, reviewing those facts, I reach the conclusion that your appointment should be terminated. This is the reason for the dismissal in that case. We say it can't simply be mine, because I'm only one of two people who has had this deputed to them. Mr. Jackson has also had a role under Section 98 deputed to him, the conduct of the investigation. And he has set about it in such a way that essentially, however honestly I approach the issue, my finding is inevitable. So in those circumstances, it would be astonishing if Section 103A was not available as an outcome to the employee. In circumstances where someone whom the employer has specifically entrusted to be involved in investigating an issue of misconduct has motivated, overwhelmingly by the protected disclosure, created an untruthful case by which I am gulled. So But to take your point, I would not in those circumstances be a puppet, but what I would be is essentially bound in reality by the conduct of Mr. Jackson. So that's what we call a corrupt process case, and we say the form that it may take is likely to be different in different contexts. So in a performance case, you're not asking, did the claimant misconduct themselves? You're saying, to what standard is the claimant performing? And there may be circumstances in which the person appointed to reach the ultimate decision carries out their own objective and direct assessment of performance, but there may be equally circumstances in which they are forced to rely upon material generated by another. And so that's what happens in this case. Hence the finding of inevitability. And that finding of inevitability is driven by things that Mr. Widmer has done as the employer, as line manager.
We obviously know a lot from the detailed findings of the tribunal about Mr. Widmer's big role in this, but are you saying that he was conducting an investigation for the purposes of the disciplinary inquiry?
No, and the reason why I'm not saying that is because there was no disciplinary inquiry and there was no investigation. It's a different kind of case. It's a performance case. So you could see, for instance, that there might be an issue that might arise in a capability case, perhaps where someone is ill, and that will take a different form again. You wouldn't have an investigation. What you might do is have a decision maker who reaches a view based on medical assessment. So, for instance, they may say, what we're going to do is refer you to occupational health. Occupational health will give us a prognosis as to whether or not you're ever likely to recover sufficiently in order to resume your duties. And if the answer is that you're not, then we will terminate your employment. When it goes to occupational health, the occupational health officer is someone who is motivated by there having been a public interest disclosure made. The occupational health officer produces a report which is just fundamentally untrue about prognosis. But the decision maker is not in a position to second guess that. And again, the decision maker's decision is effectively determined inevitably by the input from occupational health. So there will be some circumstances, like the one which I've identified in the ACAS disciplinary code, where the employer is saying, right, we're going to have an investigation now, and there will be more than one of you involved in it. So on any view, those are circumstances in which you may need to look more widely than the mind of the specific decision maker. But in other circumstances, there may not be a specific investigation of that kind. It may be that you're making an assessment which is approached in a more open textured way. So we say what one really asks is, in essence, formally, where is the material on which the decision is being made derived from? Has someone a specific responsibility conferred on them by the employer to produce that information, to form those assessments? It might be in the sickness issue, an occupational health individual. In a performance issue, it's overwhelmingly likely to be the direct line manager who has day-to-day oversight of the work that is done and is entrusted by the employer to set targets to monitor to performance.
Mr. Jones, we've got your definition of a corrupted process case, of course, in paragraph 4b of your case.
Yes.
At page 58. And no doubt we've all been looking at that, and we know that you say that this case falls within it. But can you say that Mr. Widmer was formally involved in the decision-making process? It's the sort of question I asked you a moment ago.
Yes, and I'm sorry if it appears I didn't answer it directly. You're right, it's the question, of course, that Lord Justice Underhill raises below. So what I was going to do is take you to what he has to say, where he outlines what we call a corrupted process case and says that would fall outside all, but says that doesn't help us. And he says it doesn't help us because Mr. Widmer was not an investigator. So let me try again to answer it, I hope as clearly as I can. Not every process that leads to a termination will involve a formal investigation of the kind that a conduct dismissal will involve. So unless what we want to do is take materially different approaches depending on what reason is given for termination, i.e. approach conduct cases in one way, where we say you can look more broadly, but you can never look more broadly in a performance case, you can never look more broadly in a capability case. We need to understand what the equivalent role to an investigator would be in those cases. So in a conduct case of the sort envisaged in the ACAS Code of Practice, they're saying you have one person who, as it were, puts together all the necessary evidential material, the facts necessary for a decision to be taken, and then you have someone else whose job it is to take the decision. So we say what happens in this case is materially indistinguishable. Mr. Widmer is the person who is relied on completely for the production of all the facts relating to performance that result inevitably in the dismissal. So the way to test it is to come at it from the other direction and say, was Ms. Vickers given the job of directly and objectively assessing performance, or was her role, as she described it, to review the material that existed? If her job is to perform the assessment, to put together the basic information on which the decision is taken, that's one case, but it's not this case. So yet another way of testing it is, who other than Mr. Widmer has deputed to him the obligation to form the views about her performance on a day-to-day basis and to collate the information in relation to her performance in the documentary material? The answer is no one other than Mr. Widmer. He is the man whose job it is to do that. Ms. Vickers cannot form a view unless he does that job. And once he has done that job, she effectively can't form any other view than the one that she is led to on the face of the documents that he has produced. So that it's the very fact that his involvement does produce this inevitability, which makes it clear that he's the direct equivalent of the investigator in a misconduct case. And we say that's a point that we think, with the greatest of respect to him, Lord Justice Underhill has glided over. So, can I just, for the sake of completeness, take you to what he says, which is paragraph 62 of the judgment below, which you'll find at MS 113.
Is there another ACAS code of practice for the competence and capability cases?
I don't think so. It's just disciplinary and grievances all they deal with. I should say that given the wide world of the employment practices, there are employers, for instance, who deal with even sickness as a disciplinary issue for reasons I've never quite understood, so that some organisations have a single process that deals with everyone, no matter what the potential reason for termination. Others have distinct processes which deal with capability, with conduct, and with performance.
Thank you.
So paragraph 62 of the judgment you'll find, please, at MS 134. And to put it in context, what Lord Justice Underhill is doing here is walking up a ladder, as it were, of considering different types of case and whether they might justify taking what he calls the manipulator's motivation and attributing it to the employer. He has at 60 said, what if it's a colleague with no relevant managerial responsibility? And he says, well, that won't do. At 61, as we'll come back to see, he says, what if it's the victim's line manager? And he says, I hope doing him no injustice. Well, I quite like the sound of an argument that a line manager would have his motivation attributed to the employer, but I can't reach that conclusion because of what is said in Orr and Milton Keynes counsel. And then at 62, he says, well, what if there's someone other than the ultimate decision taker, this is H, who has a formal role in the decision-making process. It says, for example, in the more elaborate forms of disciplinary procedure, Manager A is sometimes given responsibility for investigating allegations of misconduct, which are then presented to Manager B as the factual basis, albeit typically challengeable at a hearing for a disciplinary decision. So that's the kind of investigation that we've seen foreshadowed in the ACAS code. This is a refinement of a kind which did not fall for consideration in the Orr case, and there would, in my view, be, in such a case, a strong case for attributing to the employer both the motivation and the knowledge of A, even if they're not shared by B. I do not see anything in that view inconsistent with the ratio in the Orr case. In such a case, the conduct of the investigation is part of the deputed functions under Section 98. And then he goes on to disappoint us by saying, but although in the present case Mr. Widmer supplied documents to the HR department, which in turn passed to Ms. Vickers and responded to her query about the TMI complaint, that does not make him an investigator. And with the risk of repeating Lord, what I've just said to you, we accept he's not an investigator, but what he is the person upon whom the employer relies to produce all the underlying information on which the decision is taken. And we say that should be enough. So can I pause there and address the runaway horse problem? What's said by the respondents is, we're trying to tempt you down a dangerous path, and that as soon as you move from having an absolutely laser focus on the reasoning of the specific decision maker, whatever the context is, however unfair it might seem, you risk in effect unravelling the whole of unfair dismissal law, because you will then find yourself inevitably in a position where an employer is having to satisfy themselves that there's no one, as it were, out there who doesn't have information which would be relevant to their decision and might cause them to reach a different outcome. And we say, you'll not be surprised to hear that we think that a rather exaggerated concern. We're looking at a very narrow extension. Let me explain why it's narrow. It's narrow because of the requirement that the public interest disclosure has to be the reason or principal reason for the termination. Now, that it will be different in other contexts, but I want to focus for a moment on that, because that rubric of reason or principal reason applies in any unfair dismissal case. So for us to succeed in this case, we need the very strong findings that have been made by the tribunal at two levels. The first is, if in relation to Mr. Widmer's acts of detriment, what the tribunal had concluded was not that the overriding reason for what he did was the public interest disclosure, but that the public interest disclosure was a reason for his actions. We would win the detriment case, but I couldn't then argue that we should win the Section 103A case. Because if it's not the reason or the principal reason for his actions, even if he then makes the dismissal outcome inevitable, it can't be the reason or the principal reason for the dismissal. So the first limitation is we're only dealing with cases in which the manipulator, to use Lord Justice Underhill's term, is someone whose own principal motivation, principal reason for his manipulation is the public interest disclosure. But there's a second stage. We're able to say in this case, because the tribunal found, that inevitably, as a result of Mr. Widmer's actions, Ms. Vickers reached the conclusion she did. But there are likely to be any number of sets of circumstances in which that could not be said. So one might say Mr. Widmer's actions certainly influenced the outcome. They were, as it were, a taint on the dismissal process. But Ms. Vickers had all sorts of other reasons for reaching the conclusions that she had. It can't be said that it was his actions and his motivation behind the actions that made the outcome inevitable.
I've been sort of struggling with section paragraph 346, which is obviously important.
Yes.
And given it's accepted that Ms. Vickers did a bona fide assessment of her own of performance, one can see that the process was influenced by Mr. Widmer's actions, but how is it said that it was inevitable that she had reached that conclusion?
Because it's not accepted that she did a bona fide assessment of performance. She did a bona fide assessment, as it were, of the evidence that Mr. Widmer had put forward and whether that established poor performance. So the distinction is between her, as it were, going out and getting her own primary evidence and her instead simply looking at what Mr. Widmer had produced and trying to decide whether or not.
I see. Well, where is that made clear that that was all?
Well, I'm not sure that is made clear in 346 in quite the way I have made it clear. But what is undoubtedly clear from what they've had to say is they think there is, as it were, an inevitable causal chain between those two things. And it seems to me to be a necessary implication from what they've said, sorry, necessary inference from what they've had to say, that this isn't a case in which the material that Mr. Widmer had produced was just one thing that was taken into account by Ms. Vickers. And indeed, looking at the facts, it couldn't have been, because no one is suggesting that she performed any material objective assessment herself. It's the only evidence she had. So, again, just to return to the point, we're not asking for a full-scale reconstruction of the approach to attribution. We're saying in a very strong and unusual case like this, where you can be satisfied that the manipulator's reason is the protected disclosure, not just a reason, but their reason or principal reason, and that the effect they have on the decision maker is so overwhelming that it can genuinely be said that therefore the reason for the dismissal is the manipulator's reason. Only in those circumstances will you be able to impute to the employer the manipulator's acts and motivation. So can I move from...
But why would your approach to attribution here not also apply to the general inquiry relating to unfair dismissal in Section 98, where the inquiry is the reason for the dismissal? Why would your wider look at imputation not inform the exercise there?
Well, it might do. And in fact, I don't shrink from that. You'd need equally strong circumstances. But just to take an example, let's say that you had someone who is dismissed for misconduct in circumstances in which the manipulator's real reason for termination is redundancy, but they want to avoid making what might be a very generous contractual redundancy payment. A conduct investigation is established. The manipulator is the investigator, so to take the very narrow and clearest case. They want to make sure this person leaves without their redundancy payment, so they trump up misconduct evidence. The decision maker has a look at the evidence and says, inevitably, it has to be inevitably, we say, for our test to be met. Yes, it's conduct, you're terminated. Well, in those circumstances, the same analysis would apply. So we're not saying that it never strays beyond 103A, but what we are saying is it's only straying under any of these reasons as far as what is likely to be an extraordinarily rare set of circumstances, which is where you have someone who is entirely motivated by a particular reason, not being protected disclosure, and that their influence on the decision maker is so overwhelming that it becomes appropriate to describe the reason for that decision as being that particular reason.
Thank you.
Would it not extend to a circumstance where an employee was performing inadequately because he or she was being bullied by a line manager or something like that? Would your approach not require the employment tribunal to investigate the relationship between the line manager and the employee claimant?
I think not for the purposes of the reason,
If the reason was an inadequate performance, but the reason for the inadequate performance was the treatment, the bad management by the line manager, would your approach to attribution cover that circumstance?
It's materially different, I think, for this reason. What we're interested in this case about is motivations. So it's reasons for behaviour. So, my lord, in the example that you posit, you're not really interested in what the bully's motivation is at all. You're just interested in the fact that they have bullied. It's the mere act that you're interested in imputing to the employer. And it's difficult to see how you would formulate it into a reason. So you'd go to tribunal and you'd say the reason is not performance. And then the tribunal will say, well, what is the reason? And you say the reason is what? Bullying? It simply isn't, as it were, something which is sensibly described as being a reason for the termination. It would be a mitigating factor on performance, which you might well expect the tribunal want to take into account in dealing with questions of fairness if it appropriately arose. But I'm struggling, I'm afraid, to see how it arises in the context of a reason analysis. That may well just be me, but for present purposes, I'm afraid I can't see it.
Thank you.
So can I move finally to the most controversial case, the setup case? And can I suggest that it's best viewed at a kind of descending ladder of three different kinds of sets of circumstances. The first kind of case is a case where the manipulator is so senior that they'd ordinarily be thought to be part of the controlling mind of the respondent. So, as it were, on ordinary primary attribution grounds, you're dealing with someone who would ordinarily be expected to have their acts and motivations imputed to the company or attributed to the company. The next rung down the ladder, and the one which is controversial for present purposes, is cases where the manipulator has a specific authority to deal with the claimant, i.e. a line manager case. And the third kind of case is cases just involving other colleagues. So, for instance, a case in which a group of colleagues put together a plan to be rid of someone and trump up a case. That last rung on the ladder was the argument that the counsel for the claimant in Orr and Milton Keynes was not prepared to run. And in our case, we showed us prepared to run it, but we have decided that discretion is the better part of valor, and we're going to cut ordinary employees loose for the moment, if we may. And I'll explain how we do that, because we'll need to draw a line, and I'll explain what the rationale behind the line is. So we're dealing really with the first two sets of case. So can we start with very senior employees? Imagine a set of circumstances in which a financial controller working for a large company discovers that money has gone missing. And a scandal looks inevitable. So we're dealing with a public interest disclosure case. They go to the board, or they go to the chief executive, perhaps let's focus on one individual for now. And they say to the chief executive, something very badly wrong has happened here, money has vanished. We need to deal with this. If it's not dealt with, this will have to be dealt with publicly as a result of perhaps the PLC obligations owed by the company itself. The chief executive decides to suppress that information and to be rid of the financial controller. So what he does is he conspires with his fellow directors to fabricate a case of poor performance, and then they carefully select an external decision maker to whom they present the fabricated case in the assurance that they will be believed and the employee not believed. So they create an overwhelming case for poor performance of the financial controller. The external decision maker, who's not a puppet, but inevitably reaches the conclusion that the case pushes them to, decides that the financial controller should be dismissed. In other words, the chief executive plans succeeds. On a very narrow analysis of attribution, the way in which that would work out would be as follows. One would say, to whom has the functions under section 98 being deputed here? Well, the answer to that is the external decision maker. The external decision maker has reached their decision. They genuinely believe this is someone who has not performed, and in those circumstances there's no unfair dismissal. So in other words, what happens there is the deceit, the conspiracy on the part of the most senior members of the organisation is rewarded with an escape from potential liability. That if they reached the decision themselves, they would have been obviously on the hook. But by selecting an external decision maker, whilst making it inevitable that they reach the same conclusion, they escape. So when Lord Justice Underhill considered this, we'll see it paragraph 63 of his decision, which is at MS 135 in the core bundle. This was a set of circumstances in which he thought one might want to say, if there's a setup of this kind, if you're dealing with a chief executive, someone at that level of seniority, you may need to look more broadly than just the decision maker. So he says there was finally some discussion before us, the case where someone at or near the top of the management hierarchy, say to take the most extreme case, the CEO, procures a worker's dismissal by deliberately manipulating for a prescribed reason the evidence before the decision taker. Such a case falls outside Morbic LJ's formulation, quoted at paragraph 47.4 above, because the CEO, despite his or her seniority, would not have formal responsibility for making the dismissal decision. But the facts in the Orr case did not raise this issue, and it rather sticks in the throat that even in a case of this particular kind, the manipulator's motivation should not be attributed to the employer for the purposes of section 98.1. There may well be an argument for distinguishing the case of a manager in such a senior position from those considered in the preceding paragraphs, but the issue does not arise on the facts before us, and I prefer not to express a definitive view, which is no doubt entirely sensible of him. But this is a case which is not a corrupted process case, because the chief executive and the board in no sense had the responsibility for performing any sort of investigation, however widely defined. They have just constructed a dishonest case to be rid of someone. And we say in those circumstances, we share Lord Justice Underhill's concern that it would be, in a sense, extraordinary if one was able to look at that situation, and when one asked the question, what was the employer's reason for dismissal, the answer in that case would be poor performance. So the line manager example, Justice Underhill says falls within the OR ratio and is not available to us, and is in effect our case B, if you were not persuaded that this was a corrupted process case. What we say is not materially different, or ought not to be materially different in the approach which is taken. You are still dealing with someone who has had deputed to them by the employer not a responsibility for the performance of a particular function in relation to an investigation for termination, but has deputed to them the management of that individual. They are on a day-to-day basis the employer from the employee's point of view. So insofar as they were the lordships were concerned in Orr, that if you let in a case like this, a manager case, you might then have to let in a case involving all employees. You would then have to range, as it were, widely across the organisation, checking what was in everyone's minds, creating practical difficulties. We say that is not, in this case, a real danger, and there is a there is a rational basis for drawing a distinction between managers and other employees. And just pausing there, we say, of course, what we had to say in relation to corrupted process is still true here. It's still a very narrow extension, because you still need that double stage analysis producing as an outcome that the reason or principal reason was the manipulator's motivation. So we're not looking at a very broad extension on any view. Which brings me to the question, how does one rationally distinguish line managers from other employees? The obvious point of distinction is that line managers and others have a deputed responsibility. They act qua employer in relation to the people whom they manage. But why does that matter? Well, we say it's reflecting what is in truth a distinction between attribution cases and vicarious liability cases. So if one thinks about 47B1 and 1A, which we looked at earlier in relation to detriment, it's the difference between the employer being found to have subjected someone to a detriment and colleagues subjecting someone to a detriment with the effect that the employer is vicariously liable for their detriment. So, well, I think an ordinary principle in distinguishing vicarious liability cases from employer attribution cases, I entirely accept that it's not, in any real sense, an entirely bright line. It's going to have to be judged in particular sets of circumstances on the particular facts. But we recognise that there is a material distinction in law between those two things. This is where the employee, the line manager's actions, are the employer's actions, in cases where people who don't have any such deputed responsibility are actions for which the employer might be held to be vicariously liable. And we say that also reflects the distinction that one finds in the judgments of my Lords Toulson and Hodge in the Bilter case. And perhaps I can invite you to have a look very quickly at that. That's at MS 1262. And that's Authorities Bundle 4, tab 35. So we need to go to MS 1332. And paragraph 203. And you'll see what's said there is, in our view, that applies to the knowledge of directors, whether one applies the primary rule of attribution of the company's constitution, the rules of attribution of agency, or the special rules of attribution to which Lord Hoffman discussed in the Meridian Global Funds case. Where a company's liability is only vicarious, it is attributed with the responsibility for the act of the other, usually the employee, but neither the other's act nor his or her state of mind is attributed to the company. So the obvious point being made is, in circumstances where you're dealing with vicarious liability, there's no attribution. In cases where there's attribution, it's not a vicarious liability case. You have a primary responsibility. And we say that line would distinguish line manager cases from employee and colleagues generally cases. In the latter case, you're dealing with vicarious liability. In the former, you are not. That's a rational distinction, founded in an existing well-understood distinction, and would be a sensible outer boundary for even this very narrow extension that we're arguing for. And it's on that basis that we, with all due respect to our original submissions, now abandon colleagues generally in the setup case and limit it to cases where you're dealing either with someone sufficiently senior that on primary attribution principles you would expect their acts and motivation to be attributed, or someone who has a specific deputed responsibility in relation to individuals. So that brings us, on the face of it, in relation to the second category, into conflict with what's said, excuse me, in OR. And I'm about to move on to the question of case law and look at OR specifically. But just to explain where we're going, you'll have heard me say already, we think the problem with OR is firstly that it has too broad an idea of what the practical consequences might be, not conscious of this sort of limitation that we've described in this case, but also that it starts from an assumption that the employer is looking for an honest outcome. And in a set-up case, the employer is not looking for an honest outcome. It's the opposite. They are looking to procure a dismissal and to use deceit to get there. And what the principle of attribution should not be is a defence in those circumstances. It shouldn't allow someone off the hook if they are sufficiently good at hiding what they're up to. We say there's a particular irony in a case involving public interest disclosure, because of course the whole point of public interest disclosure law is it is people being protected where they make public, where they bring out into the light what an employer would rather they didn't. So if an employer is able to defeat their Section 103A claim by being sufficiently successfully deceitful and ensuring that their true motivation is concealed from the specific individual they've identified to make the decision, there would be a bitter irony in that. But I accept that bitter irony is not a canon of construction, so I make the point rather cheaply. Forgive me. So just before we finish on proposed answers, we say that our approach avoids certain disadvantages which would arise as a result of not allowing someone to bring a Section 103A claim. And they fall into broadly three categories: access to remedies, avoidance of hurdles, and perverse incentives. And I can deal, I hope, very quickly with them. In terms of access to remedies, one remedy which is available in a protected disclosure case, which isn't available in other cases, is, and specifically is not available in a detriment case, is an application for interim relief. And for that we need to have, if we made the first authorities bundle, and to look at MS 682. So you'll see, excuse me, here, section heading, interim relief pending determination of complaint. Subsection 1, an employee who presents a complaint to an employment tribunal that he has been unfairly dismissed and that the reason, or if more than one, the principal reason for the dismissal is one of those specified in, and you'll see 103A is at subsection A little Roman 1. They may apply to the tribunal for interim relief. As to what the tribunal then considers, you'll find that at section 129, which is at MS page 686. If the tribunal decides that interim relief ought to be made available, you'll see at subsection 3, they ask the employer, if present, whether he's willing, pending the determination or settlement of the complaint, to reinstate the employee, or be, if not, to re-engage him. So there can be an interim reinstatement or re-engagement which preserves the employment relationship, in fact, preserves keeping the employee at work, either in their existing role, hence reinstatement, or in some other role, re-engagement. And for the purposes of subsection 3b, which is re-engagement, terms and conditions must not be less favourable than those that which have been applicable to him if he'd not been dismissed. So in circumstances in which an employer is trying to get an employee out of the door because they have made a protected disclosure, it's open to the tribunal to ask the employer whether they're willing to reinstate or re-engage. If the employer says they are willing to do that, then subsection 5, that order is made. If the employer states they're willing to re-engage, and specifies the terms and conditions on which they're willing to do so, then the employee at subsection 7 is asked whether they're willing to accept the job on those terms and conditions, and if they are, that order is made. But if the employee is not willing to accept the job on those terms and conditions, and the tribunal is of the opinion that refusal is reasonable, the tribunal can make an order for the continuation of his contract of employment. Otherwise, the tribunal should make no order.
How does this work in the real world of the tribunal, Mr. Jones? How practicable is it for the tribunal on an interim application to consider whether it is likely that it will be finding that the reason for the dismissal was whistleblowing or whatever it might be? I mean, that's the issue. That's a big issue. That's on your analysis in particular. It's a hugely complicated issue.
It is. So, Lord, it's not going to surprise you to hear that these are not very common occurrences. the award of interim relief. They can be peculiarly important in some cases. But the test is, in effect, even worse than it appears on this piece of paper, because I'm not going to be able to remember the name of the authority for which, forgive me, but the authority establishes that when you're looking at likely, it's effectively substantially more likely than not.
I see.
So I'm told that if one looks at the annotation at 689, one sees a citation there under case note. What a tribunal has to do in an application for interim relief is to examine the material put before it, listen to submissions, and decide whether at the final hearing on the merits that it is likely that the tribunal will find that the reasons for dismissal is one of those listed. They referred to.
Well, does it follow that this is not a very big point, Mr. Jones?
Well, it's a very big point for some people. It's not, for present purposes, a very big point in this case. But what it is a highly unusual remedy which is made available specifically because it is understood that there's a special danger in cases of this sort. What happens is the employer wants an employee out and not earning as a way of suppressing the protected disclosure. And that in the continuation of employment order, which we would find under section 130, but which regrettably is not in the bundle of authorities. That's something which is short of reinstatement or re-engagement, but effectively preserves the employment relationship in place for the purposes of pay and other important factors. So it preserves, for instance, your continuity of employment. It preserves your access to pension rights and service for the purposes of pension rights. So, Lord, if you were to say to me, are we in a position where Parliament has created what on the face of it would be a highly valuable and useful interim remedy, but then set about it such a test that in practice it's rare for an employee to be able to make use of it? The answer is yes. In fact, there are all sorts of ways in which it's more difficult, one of which is that you have to bring on your application very quickly indeed. So the prospect of you establishing that it's substantially more likely than not that you're going to win at the final hearing is made all the harder. But it is a real right, and if you can get it, it can be astonishingly important to the individual because of the effects it has on pay, pension, etc. The other thing which is available at a final hearing in a section 103A case, but which isn't otherwise available, is of course the final order for reinstatement or re-engagement. So you can't, in a detriment case, win and then get an order from the tribunal to be reinstated or re-engaged. So if you're in a position where rather than saying, I've simply had enough of this employer, I want nothing further to do with them, I will take the compensation and go. If you are, as whistleblowers very often are, someone who has devoted long service to a company and has taken a brave decision to stand up and make a protected disclosure at risk to their career, those remedies, reinstatement and re-engagement, are in essence the only possible path back to re-establishing that career. So I can't pretend that reinstatement or re-engagement orders are all that common, not least because it's open to employers, no doubt you know, simply to refuse to implement them and pay an additional award instead, and sometimes employers will do that. But if there is to be any hope of re-establishing the career, that is the only way the tribunal has of making that happen. Now, you'll have seen, I know because you've read, it's been apparent from the questions, that you have read what we've had to say in the case quite carefully, so I can hope deal with questions of hurdles very quickly indeed. There are material differences between the way in which you enforce a detriment claim and the way in which you enforce a dismissal claim, the most obvious of which being when time starts running. So time starts running from the detriment in a detriment claim, time starts running from the dismissal in a dismissal claim. What's said in this case is, because you can, which is now clear from the Osipov case, get compensation for loss of earnings arising out of a termination which is consequent on a detriment, you have an alternative path to justice, albeit not one which is ever going to result in you being re-employed, which we say is, I've just said, is a material difference. But this is a case in which time points are being run by the Royal Mail. So even though I don't think it is disputed that the tribunal's findings that protected disclosures were made, detriments were suffered, and those have had consequences, all of that is not disputed between the parties. Whether or not this Osipov remedy should be made available to the claimant is disputed, and one of the bases on which it is disputed is time. So why is that important? Well, because it puts an employee potentially in a very difficult situation. It's the situation this claimant was in, which is, what if you think your line manager is, as it were, setting you up to fail, but the employer is putting in place an approach to investigate whether or not you should be dismissed, and you're seeking to run a grievance to get that sorted out. What that means is employees have really two choices that they can make. They can either do, as I suggested earlier, make for the door and say, I'm going to treat this as a constructive dismissal. I'm obviously being set up to fail. You cannot reasonably expect me to hang around here whilst that happens. Away I go, and I then bring my basically irresistible Section 103A claim. Or you say, what I'm going to try and do is sort this by putting in a grievance and seeing if I can make this happen, make this stop. But by doing that, you are faced with a situation where time is running against you in relation to the detriment. So you can find yourself in a situation where by the time you come to the dismissal, which is merely a consequence of the detriment, 3 months have passed if you spend a period off sick with stress, if you've been pursuing a grievance that ultimately went nowhere. If you've made that choice, you may find yourself in a position where you're told that whereas in theory Osipov damages might get you what an unfair dismissal claim might get you, you can't have them because time has run. So it puts an employee in a very difficult position that they simply would not be in if Section 103A were available.
What is the time limit on an Osipov claim?
The time limit is 3 months from the date of detriment.
Or from the date of the termination of a continuing detriment?
Yes.
Yes.
So that's one of the two ways. There is open to a tribunal, of course, circumstances in which they can approach the time question differently. So if there are ongoing detriments, which is not ongoing consequences of detriments,
No.
but ongoing detriments, instances of detriments, you may be able to, as it were, to string them together. But there's a need for similarity. It's a series of similar detriments. So even if you can show a series of detriments, that may still not get you there. And there is, of course, circumstances in which you can prove that time has not run if you can show it was not reasonably practicable to bring your claim in time. Now, that's a much less generous test than the test, as you know, that is implied in discrimination cases, where it's a question of justice and equity for the extension of time. In circumstances in which an employee has determined that they think they are being subjected to a detriment, but taken the decision to pursue the grievance route, it's very difficult to say in those circumstances that it was not reasonably practicable to commence the claim. There's a case, I think, called Palmer and Southend, which deals with unfair dismissal cases and grievances, in which that is said that if what you do is effectively elect to pursue a grievance, time may run against you. So yes, there are ways of extending or approaching time differently, but it remains a real problem, particularly for someone who, like the claimant, thinks that their answer lies where an employee's answer ought to lie, which is grieving to an employer and saying, can you please sort this out and make this stop?
Yes. Would it be a detriment if a line manager subjected a dishonest or incomplete report? There would be a detriment at the date that he submitted it to someone investigating a person's performance.
Yes.
Would it also be a detriment if there was a gap between the submission of that report and the hearing or determination of the assessment of performance, if the line manager failed to withdraw what he knew was a dishonest report?
Well, I certainly wouldn't rule out trying that as an argument, not least because it may be we end up having to. So I wouldn't want in front of the Supreme Court to say that was completely unarguable. But I think the difficulty with it is that one has there are a whole series of authorities, for instance, which relate to decisions which are taken not to increase someone's pay. And the argument which is consistently run is one which is an analogue, my lord, of the argument which you put, which is the employee may say, well, each subsequent day when my pay isn't raised, well, that's a further detriment, that's a further failure. But the approach that the courts has tended to take is to say, well, if there's an act, plain act you're complaining about, in this case a decision not to raise pay, that's the act that you're complaining about. Each subsequent day in which you're not paid as much is a consequence of that decision. I need to be clear because I'm basically, as you'll tell, busking from authorities I'm not naming, that you know, with a particular tribunal or a particular appeal tribunal, you may be able to persuade them that, for instance, in circumstances of reasonable adjustments, sometimes the AT has been persuaded that a continued failure to make a reasonable adjustment is a continuous legal wrong and not a single failure with an ongoing consequence.
Well, I mean, if you're dealing with dishonest behaviour, which in a case such as this we may be, then a fraudulent representation is treated in law as a continuing representation. So if someone is being dismissed because they are being subjected to a protected disclosure, then that it may at least be arguable that there is a continuing representation by the line manager right up to the point where the decision is taken.
Well, I don't think I could go further than to say I very much see the force of that argument, and you will understand why it's immediately attractive to us in one way on this side of the room. It might create all sorts of difficulties for what we have to say about the hurdles that might otherwise need to be overleapt.
Yes.
Certainly, if in the course of a judgment of this court, it was suggested that in a case of that kind, there might be some ongoing obligation to correct dishonest reports, I think it would be received with great joy by the representatives of claimants. It's probably some tearing of hair by the representatives of respondents, but...
Well, I think it is part of the existing law of fraudulent representation, but be that as it may.
Well, they may well have an application, I can see that. We have taken in the case a point about the employer's defence, from which I'm now going to have to retreat in some embarrassment. We said you can, in a detriment action, rely on the employer's defence by showing in effect that you took all reasonable steps to ensure that the detriment didn't occur. But what I should have observed is that, of course, only applies in vicarious liability cases and not in direct attribution cases.
I'd like to make a note against your paragraph. So which paragraph are we talking about?
Yes, sorry, it's paragraph 17 at MS 63.
Sorry, can you repeat the point?
Yes, a reasonable steps defence is only available to a vicarious liability claim under section 47B1A and not under 47B.
Thank you.
I hope that's the last retreating I do. Turning to the last point under this heading, perverse incentive. It's a simple point. We say if the very limited understanding of, or the very restrictive approach or interpretation of law is taken, we find ourselves in a very odd position, which is that the better a manipulator is at deceiving a decision maker, and the less the decision maker does to go behind what they're being told, to go beyond what the manipulator is telling them, the more likely they are to take it at face value, the more likely it is that a Section 103A claim will not be available. We say that, and on its face, obviously antithetical to the statutory protective purpose, can't be right. The better a dissembler the manipulator is, and the lazier an investigator the decision maker is, the less likely it is that a respondent should end up being liable at the end of the day. So that takes me to the third section, which is case law. And I promised you, and I hope to keep to that promise, that there won't be very much for us to look at. We're going to look at case law in three sections: case law on attribution generally, case law on the reason in unfair dismissal cases, and case law on attribution specifically in unfair dismissal cases. And to some extent, we've covered much of this already. So far as attribution generally is concerned, you will have seen that in the bundles of authority are both Meridian and Bilter, and issues are raised in those cases which go comfortably beyond the ability of an employment lawyer to not only to address you on but understand. But what seems to be agreed between the party, and I think plain on the face of the judgments in those cases, is that the attribution question, whether or not the employer can have attributed to them the knowledge and motive of an employee, will depend upon what Lord Neuberger described in Bilter as the nature and factual context of the claim in question. So he says that at paragraph 9 of Bilter, which you'll find the Bilter authority starts at 1262. It's in the fourth authorities bundle. At tab 35. And paragraph 9 is at page MS 1272. Sorry. So it says, I agree with Lord Mance's analysis that the question is simply an open one, whether or not it is appropriate to attribute an action by or a state of mind of a company director or agent to the company or the agent's principal in relation to a particular claim against the company or the principal must depend on the nature and factual context of the claim in question. So you can see he's agreeing with Lord Mance, and that passage, the relevant passage of his judgment, you will find at paragraph 41, which is at MS 1279. It says, as Lord Hoffman made clear in Meridian Global, the key to any question of attribution is ultimately always to be found in considerations of context and purpose. The question is whose act or knowledge or state of mind is for the purpose of the relevant rule to count as the act, knowledge or state of mind as the company. And that's the formulation we'll see was carried across into Orr and Milton Keynes. Lord Walker said recently in Moulin Global that one of the fundamental points to be taken from Meridian is the importance of context. In any problem of attribution, even when no statute is involved, some courts have suggested the distinction between acts and state of mind of, on the one hand, a company's directing mind and will or alter ego, and on the other, an ordinary employer-agent, may be relevant in the context of third-party relationships. Goes on to say that's academically controversial, and then concludes by saying any such distinction cannot in any event override the need for attention to the context and purpose in and for which attribution is evoked and disclaimed. I don't think, as I understand it, that there really is any difference between my learned friend Mr. Gorton and I, who no doubt indicated there is. That's the approach that you take. You're asking yourself, in essence, what's the context here? What's the purpose of the legislation? How should we approach the question of attribution in the light of that? So we say, well, the context, the immediate context, is a statutory scheme for the protection of whistleblowers. And we say it's worth bearing in mind that this is a protection that the legislation clearly signals is of particular importance. And it does that in a number of ways. Firstly, dismissal for the reason that you've made a protected disclosure is automatically unfair. It's one of those groups of reasons which obviates the need to look into the particular circumstances of fairness. If you dismiss for this reason, it's always and automatically unfair. The second is it's a day one protection. So for ordinary unfair dismissal, you obviously have to have worked your qualifying period of service. For unfair dismissal on this basis, you do not. It was given to you from the very first day of your employment. Unfair dismissal compensation for loss of earnings is notoriously capped. It isn't in a public interest disclosure case. So it's a day one right for uncapped compensation in circumstances where if you're dismissed for that reason, it's automatically unfair, and built around it, as we've already seen, are, even if only rarely in fact invoked, is a special regime for interim relief. So all of these things mark it out as something that the law is taking particularly seriously. The purpose, we say, that's the context, the purpose is determining whether an employee should be treated as having been dismissed for the reason that they have made a protected disclosure. And we say that should not, you're approaching that question, yes, you must take into account, we concede immediately, the practical implications and consequences of the approach that we are suggesting. How could you not? But one must not leave oneself in a position where we say, as here, it is too easy for an employer to defeat liability for unfair dismissal by effectively acting badly, particularly in the context, as we said with bitter irony, of a protection which is intended to make it easier for employers' bad behaviour to be identified and addressed. So case law on the reason for unfair dismissal cases, again, I think we can take something of a gallop because there's, as far as I can tell, no disagreement between the parties on it. We are dealing here with what is now Section 98(1) of the Employment Rights Act, 1996. You'll find that at MS 593 in the first volume of authorities. So when pupils come to chambers and they say, what's the difference between a wrongful dismissal and an unfair dismissal? The first thing we say to them is, wrongful dismissal, no one cares why you've dismissed. All the law of wrongful dismissal is focused upon is, did you terminate lawfully? Did you comply with the obligations you needed to comply with in order to bring about a lawful termination of the contract? Did you give the appropriate period of notice? Or were you in circumstances where you weren't obliged to give one? Unfair dismissal is all about the reason for termination. It's not only the principal focus, as we'll see at 98, it's the first focus of unfair dismissal law. So 98(1), Chapter 1, right not to be unfairly dismissed, 98(1), in determining for the purpose of this part whether the dismissal of an employee is fair or unfair, it's for the employer to show, A, the reason, or if more than one, the principal reason for the dismissal. So the very first thing, most important question on fairness is what's the reason? The obligation is on the employer to show it. So, of course, that begs the question, well, what counts as a reason? What are we talking about here? When answering that question, the first thing to note is that there is nothing here, nothing in Section 98, or indeed elsewhere in the Employment Rights Act, which expressly deals with the attribution question. It's talking about the employer's reason, but it isn't telling you how you approach that question. The authorities, the two authorities we're going to look at in relation to the reason, similarly elucidate what a reason is, but don't expressly address the attribution question. They don't have in mind the kind of difficult sets of circumstances which have been raised in this case. So the locus classicus is Abernethy, Mott-Hay and Anderson. You'll find that at MS 952 in the second bundle of authorities.
Yes, the essence of the submission you're developing now is that Abernethy and Davis require it to be a reason in the employer's mind, but they don't tell you whose actual mind is to be attributed to the employer.
Well, Lord, exactly. So perhaps I can spare you taking you to the...
No, by all means do, but I just wanted to make sure I knew where you were going, if that was what you were saying.
I'm in a sense glad I'm so transparent. That's what I'm hoping to establish, that when you look at these reasons, look at the authorities and reasons, I'll read you from my note what Lord Justice Ken says in Abernethy: a reason for the dismissal of an employee is a set of facts known to the employer and defined where it may be of beliefs held by him which cause him to dismiss the employee.
I didn't want to take you from referring to, what was the MS number of that quote?
So that is at MS 959.
59.
Well, that's the statement that's approved in Davis, isn't it?
which is where I would go next, and only for the purpose of saying it's approved in Davis. So, as it were, the highest authority having been approved in the House of Lords. So we need to think about cases in the third group, which are ones which expressly consider attribution in unfair dismissal cases, which there are effectively two. Or Milton Keynes Council, and this case below. So all you'll find at MS 1120, which is an Authorities Bundle 3 at tab 28. And summarising the facts, it concerns a youth worker who committed 2 acts of misconduct. He discussed and alleged sexual assault with young people at a community centre when he'd been instructed not to. But more importantly, for the way in which the decision in Orr Milton Keynes is ultimately determined, it was said that he'd behaved in an offensive and insubordinate manner in a conversation with his line manager. There was a disciplinary hearing which he didn't attend, he was dismissed. His line manager, it turned out, had provoked him by trying to engineer a reduction in his working hours and by making a racist remark. So just pausing there, it's the kind of situation which, my lord, you raised earlier when you talked about what happens if someone is bullying someone into poor performance. This is not a case of a line manager who, for a prohibited reason, is seeking to bring about a termination. It's a case in which there is information about line managers' acts which may have been relevant in mitigation terms in the disciplinary hearing, of which the disciplinary manager, disciplinary decision maker, was unaware. So that did not come out at the disciplinary hearing. The dismissal occurs in ignorance of the fact, and the question was whether the provocation was relevant to the fairness of the dismissal. So this is a case concerned with 98.4, not 98.1, which is the provision we've just seen which deals with reason, albeit, as we'll see in the Court of Appeal in this case, Lord Justice Underhill thought nothing turned on that distinction, and we are not proposing to persuade you that anything does. So what was the argument on the appeal? We'll see it set out, paragraph 16 at MS 1126. We'll see the limited way in which Mr. O'Dare for the claimant put the case. It says he limits his case to knowledge held at a sufficient level of seniority to make it the council's knowledge. Here, for example, he says that what Mr. Orr's manager did, said and knew in the course of managing him was done, said and known on the council's behalf. In that deliberately restricted sense, it is factually as well as legally right to attribute it to the council. It means no doubt that a bona fide decision can be undone through no fault of the decision maker, but that is a price which both equity and the substantial merits of the case make it fair for an organisation to pay. I'm going to pause there and perhaps disappoint you. One of the arguments which was run in this case, or considered in this case, was the impact under section 98.4 of the requirement to look at equity and the substantial merits of the case. I know in Sandwell and in other cases, it has been said there is, as it were, there's an interesting issue to be determined as to whether Foley in the post office was right and whether it should be open to a tribunal, in effect, to substitute its decision for the decision of an employer in circumstances in which they are not convinced that this was a fair dismissal. And this is not the case, I'm afraid, in which that matter is going to arise for determination. We come very close, but we are, of course, a case where we're dealing with section 103A, where it's automatically unfair if the dismissal is for that reason. So I'm quoting at paragraph 16 from Lord Justice Sedley's decision. He's in the minority. I want to deal with how he deals with it and then with how the majority deals with it. One of the arguments which was put to him, and put indeed to the court by Simon Cheatham, was that if in this case what you did was make a disciplinary decision maker aware of something they couldn't have found out whilst conducting the investigation in a bona fide and straightforward way, that would in effect be to overrule Foley. Instead of asking, is this an employer who has a genuine belief based on reasonable grounds, arrived at as a result of an investigation that fell within the band of reasonable responses and who has reached a decision to dismiss which falls within the range of reasonable responses, you would be saying all of that is true and yet it's still an unfair dismissal because of material that was not immediately available to you and which you couldn't reasonably have found as a result of the investigation. That's different to this case because it's not suggested, for instance, that this is a corrupted process case, which is why Lord Justice Underhill is able to say, when we come to this case below in the Court of Appeal, that a corrupted process case falls outside the ratio here. This is saying not the employer should have imputed to them the knowledge of someone who had a material impact, who's misled you in a way which has had a material impact or an overwhelming and determinative and inevitable impact on the decision, or who's had a formal role in the investigation. It is saying, what if there is information out there in the mind of someone who can be said to represent the employer, which would have made a difference to the outcome? So Lord Justice Sedley takes at paragraph 19 a narrow point, which we're going to invite you to accept, but also then goes on to make a much broader point, and we don't go as far as he does. So he says, in my judgment, the doctrine of Foley and Post Office does not affect the narrow question put before us, which relates not to the fairness of what the employer has done, but to what the employer knew when doing it. And we think that's right. So the question as to who is the employer and what do they know is a logically prior question. You only get to the fairness question once you've decided what the reason is. So he says, I would hold that a person to whom a corporate employer deputes a decision about dismissal, and you see there he has in mind an individual rather than a number of individuals, not only decides but inquires on behalf of the employer. In so doing, he or she has to be taken to know not only those things which he or she ought to know, but any other facts which he actually knows. Among such facts, it seems to me, are facts known to persons who in some realistic and identifiable way represent the employer in its relations with the employee concerned. So that's an incredibly wide, with respect to him, formulation. If there's anyone out there in the organisation who knows something and who could afford to be treated as the employer in any specific context, because they in an identifiable way represent the employer, and that, he says, is enough. We don't go that far. What we say is significant is knowledge held in the mind either of someone who has I'm going to call for the moment a material role in the process which results in termination, a corrupted process case, or someone who is set out, as it were, to set up the employee, who is procuring the termination and deliberately doing so.
And I think you limit that to somebody who's in a management relationship with the employee.
Yes.
But apart from the width of what was being suggested here to be imputed, are you commending an imputation to the decision maker or an imputation to the employer?
That's my next point about where it seems to me he takes what one might call a somewhat unusual approach. So that's, we'll already pick up exactly where I wanted to go, which is paragraph 19. He says, which is in fact where we were, forgive me. What he seems to be doing, as you describe, is saying it is impossible to impute to the decision maker information, rather than asking what the employer knows. It's saying we're going to deem the decision maker to have particular information in their mind. And you can see immediately why that might be a startling proposition. And indeed, in the course of Lord Justice Aiken's decision, he says, well, that seems to be to turn the principle of attribution on its head. So rather than looking to attribute to an employer what an employee knows, you're here looking to attribute to an employee what the employer knows. And that's a materially different approach. And we agree. That is
Where does Lord Justice Aiken say that?
So I was looking for it. So he's dealing with Meridian. Sorry? 60. Sorry, you're right. It's Lord Justice Moore-Bick at paragraph 60.
Oh, very well.
So he says, B, however, in my view, it would be contrary to the language of the statute to hold the employer had acted unreasonably and unfairly if, in fact, he had done all that could reasonably be expected of him and had made a decision that was reasonable in all the circumstances. That's why it's important to identify whose state of mind is intended to count. To impute to that person knowledge held by others is to reverse the principles of attribution formulated in Meridian Global Funds Management and to place the whole exercise on an artificial footing. So, just to be clear, we're not suggesting that Ms. Vickers has attributed or imputed to her Mr. Widmer's knowledge, but what we are saying is that when you look at the entire context and ask whose decision, whose reason is at issue here, you do then have to look at what Mr. Widmer had in his mind for the reasons that I've already set out, probably over repetitively. So Lord Justice Sedley, as it were, buys the argument. Lord Justices Moore-Bick and Aiken do not. And the most significant passages from Lord Justice Moore-Bick's decision really begin at paragraph 55 of his judgment, which you'll find at page 1136. See from the first sentence, an immediate focus on practical application. It says, Part 10 of the 1996 Act must be interpreted in a manner which makes it capable of practical application in the workplace. Whether the employer is an individual or a large organisation, if the employer is a large organisation with many employees, it will inevitably be necessary to delegate responsibility for dealing with routine employment problems to suitably qualified managers who have authority to take decisions on the behalf of the organisation. In my view, Parliament must be taken to have recognised that, and although the organisation remains the employer, some decisions, including in some circumstances the decision to dismiss an individual employee, will be taken on its behalf by someone who is not at the most senior level. And we entirely agree with that, and we agree that there has to be proper consideration of practical applications, which is one of the reasons we've tried to keep our extension so narrowly bound. It then moves on at paragraph 56 and 57 to consider Meridian. And he says he cites at C from the passage to the judgment of Lord Hoffman, last few lines of that citation, whose act or knowledge or state of mind for this purpose intended to count as the act, etc., of the company. One finds the answer to this question by applying the usual canons of interpretation, taking into account the language of the rule, it's a statute and its content and policy. And then, if I can take you to 58, we come to the passage which I cited earlier. The answer, this is at G, the answer to the question, whose knowledge or state of mind was for this purpose intended to count as the knowledge or state of mind of the employer, will be the person who was deputed to carry out the employer's functions under Section 98. And then he goes on to say, well, who's that? And at 59, he says, in the present case, that person was Mr. Cove, who is specifically the investigator and decision maker. Risk of boring you, you heard me say repeatedly already, there may be circumstances, and this is significant for the corrupted process case, in which that deputation is to more than one person. So in practice, more than one person is involved in either collating the material necessary for a decision to be taken and then taking it, or carrying out an investigation, again to collate evidence and then taking the decision. So we don't read what has been said by Lord Justice Moore-Bick here is that you must always have a specific individual. Indeed, that would be inconsistent with what he says at 58. The test is, in effect, to whom is being deputed the necessary functions which result in the decision to terminate. And we say that can be broader than the specific decision maker on occasion. So Lord Justice Aikens agrees with him. That's error 86. Page 1145, MS 1145. He says, halfway through the paragraph, although Mr. O'Dare has raised a novel and interesting argument, always dread words, I hope he will forgive me for not rejecting the argument. Therefore, I respectfully cannot agree with Sedley, Lord Justice Sedley, that the case should be remitted to an employment tribunal for a finding on the issue identified above. So it seems to me a clear judgment, and we don't, properly interpreted, disagree with what it has to say. In most cases, in the simplest case, you're unlikely to need to look beyond the mind of the individual decision maker. But it is inherent in the test, which has been set out in OR, that you look at to whom the functions under Section 98 is being deputed, that you may need to do so, because there may be, as it were, more than one deputy, who is properly identifiable as being the person who acts on behalf of the employer in terms of either collating the information or reviewing the information as part of that process, will likely differ from case to case. What is harder, and that's to reconcile with the judgment in OR, we immediately admit, is the setup case, not the corrupted process case, but the setup case. What we do say is when you look and reflect upon the passages which I cited, the obvious concern of their lordships is an employer who is bona fide investigating something shouldn't find themselves in circumstances where they're effectively on the hook as a result of knowledge that they couldn't reasonably have discovered as a result of their investigation. We say in a setup case, where you have someone who is capable of being the employer, who is deliberately setting out to make sure that the outcome is adverse to the employee, that obviously is not the sort of bona fide exercise that their lordships had in mind. And that is true even if you think the Mr. Cove or the Miss Vickers is setting about it in a bona fide way, because if it is inevitable they will reach the conclusion they do as a result of the manipulator, in those circumstances, however bona fide their approach may be, they are not going to be able to escape from implementing the setup, from being the vessel through which the dismissal is procured by the manipulator. And we say if what had been said, it's just not clear from the Court of Appeal decision what position they would have adopted in a case of that sort. So if you take the example that we're going to come to now, that Lord Justice Underwood had in mind, you have in effect a corrupt CEO who is trying to set up termination. That's not the sort of issue that they were considering, and Lord Justice Underhill is right to say it's not determined by all. He's also wise to say that he wasn't going to determine it himself. So can we come to the Jhuti decision below, which is at MS 113 in the core bundle. And I hope we can deal with this quickly because I've taken you effectively to the relevant passages already, so this is a way probably unnecessarily of reminding you of them. We're looking at 133. And at paragraph 57, he accepted my learned friend Mr. Gorton's submission that for the purpose of determining the reason for the dismissal under section 98(1) of the 1996 Act, the tribunal is obliged to consider only the mental process of the person or persons who was or were authorised and did take the decision to dismiss. So we do quarrel with that formulation. The reason why we quarrel with it is because it's inconsistent with what he goes on to say, the paragraph 62, about how in a case where someone who is someone other than the ultimate decision taker, that's his language at paragraph 62 and 134, has a formal role in the decision-making process. In his view, that might well be a case in which you might need to impute or attribute the motivations and acts of that other person to the employer. So at 57, he is putting the test more narrowly than he appears to think it should be phrased later in the same judgment. Not who think who has had deputed to them the taking of the decision to dismiss, but who has deputed to them, as it were, a role in the process which results in the decision to dismiss. Subject to that, he and we, and I think the Court of Appeal, are effectively agreed. He then goes on to climb the ladder I described earlier. We disagree with what he has to say at 61, where he says that he thinks the ratio in Orr and Milton Keynes precludes, in what we must be a set-up case, a line manager's determination to set up being sufficient, even in circumstances where their reason is, in an overriding sense, the protected disclosure, and even in circumstances where the decision-maker's decision is inevitably determined by that line manager's input, and we say that can't be right. So we do materially disagree with what he has to say there, and insofar as that involves us disagreeing with the approach taken by Orr, we do, and the basis of the distinctions I've already said is that Orr assumes you're looking at a bona fide exercise. In a set-up case, you are not, and that's a material distinction. So where does the law get us to? We say, in summary, 5 points. Attribution depends on context. Orr says that one attributes the knowledge of those deputed to carry out the employer's functions in section 98. We say a corrupted process case would not be inconsistent with Orr, and we agree with what Lord Justice Underhill says on that issue in Jhuti below. Lord Justice Underhill thinks Orr might be distinguished in a case where the manipulator is at or near the top of the management hierarchy. So a set-up case involving someone whose acts and motivations would fall to be treated as the company's under primary attribution tests. He would have had sympathy for an argument that attribution would occur where the manipulator is a line manager, but he thinks that would be contrary to Orr. On that we disagree, and if we're wrong about our interpretation, we invite you to overrule Orr insofar as is necessary to produce the just result that we're seeking. And that takes me to dealing with the last two sections of the submissions, responding to some of the arguments which have been raised against our approach, and then remission. I notice that it's 10 to 1. I'm more than happy to keep going and stop at whatever point we've reached at 1 o'clock, or you may think that this is an appropriate moment to break.
Well, if we think it's an appropriate moment to break, then we'll come back at 10 to 2.
Yes.
So I think I'd prefer to carry on, if you don't mind.
My policy is always I'll keep talking as long as people are prepared to keep listening. So I will.
Well, our ears turn off at 1 o'clock.
Understood. Now, the respondent has a lot to say. It will not surprise you to hear, not least because you've read the case of the respondent, about our arguments. I'm not always clear, and again, this is more than likely me rather than the result of how the case has been drafted, always quite what they're saying. So for the most part, I'm going to take, I hope, the sensible course of reserving response until I've heard the arguments set out and tested. But there are one or two, as it were, key points that might be worth making now. And it may be helpful to have the respondent's case available to you. I'm going to start, please, at MS 88. Which is where the respondent's case moves expressly to the question of attribution. There are a number of subheadings under this section. There is, as it were, a sort of missing one under attribution. Again, I don't say that by way of criticism. You might imagine a subheading which said here, primary attribution cases. So paragraph 27, there's a long extract set out from Meridian. And at paragraph 28, what is said is attribution is a method of imposing on the corporate entity liability for those acts that are attributed to it under this doctrine. that liability is strict. The effect of the doctrine is that the act or motivation of the individual becomes the act or motivation of the company. Don't disagree with any of that. 20(9), they say, in this case, for the purposes of the primary rule of attribution, the intent of the corporation, here the respondent, could not be clearer. The respondent has delegated through its procedure responsibility to act on its behalf to the decision-maker, Ms. Vickers, and the appeal decision-maker, Ms. Madden. Now, focusing for the moment on Ms. Vickers, for the reason that Ms. Madden's decision is taken post-termination. So far as Ms. Vickers is concerned, we of course accept, so I want to make this clear immediately, that she has deputed to her part of the employer's functions under Section 98. So she has, as it were, the genuine belief, but in terms of the grounds and the reasonable investigation, all she has ever purported to do is review the material for which Mr. Widmer is the sole source. So again, we say he's the one that has deputed to him, as it were, the obligation to make a proper assessment of the capability and the performance of the claimant. They move from primary attribution to vicarious liability. We think vicarious liability is essentially a red herring in this case. So nothing that I've said to you so far really turns on vicarious liability principles, other than that I have deployed it to hive off, in the setup case, a setup created by bare colleagues rather than someone who has some sort of management responsibility. But the argument was run, as I understand it, is twofold. Firstly, at paragraph 32, it said, "It is of significance that Parliament has exclusively used the mechanism of vicarious liability to impute the act of an individual to the employer. It has never sought to use any general mechanism for attribution." Well, we say that's just wrong. It's obvious that in 47B1 and in 103A, you are dealing with, there is a need for an attribution principle. So in detriment cases, even before vicarious liability was possible, even before 47B1A was enacted, there was a 47B1 in which employers were capable of subjecting employees to detriments. And of course, for a corporate employer, that must inevitably and invariably be on the basis of an attribution. They can't themselves do it. They have to act through real people. That must be attribution. So what's said here at 32 is, we say, just incorrect. It's not clear how that develops into the argument which is summarised at paragraph 36. Again, I hope I don't do it any injustice, but what it effectively says is, if we're right about attribution, effectively the amendments that were made to section 47B to add section 47B1 would have been unnecessary. And we say we don't really follow that for the reasons that I'm about to explain. So the first point is, we need to remember, no doubt you can forget, that this is an appeal which is concerned with attribution under section 103A and not any attribution under section 47B. The pre-amendment form of section 47B you will find set out in the judgment in Fessett or Feckett, I'm never quite sure how one pronounces it, at MS 1151. But I can, rather than take you there, I can read to you what it says. It just said, as one would expect, a worker has the right not to be subjected to any any act or any deliberate failure to act by his employer, done on the ground that the worker has made a protected disclosure. So since the provision talks about acts done by the employer and the employer's grounds for those acts, it's immediately apparent that under the law that existed prior to the amendment, there had to be an attribution test. Whose acts and whose grounds are to be attributed to the employer is an entirely distinct question from whether the employer should be vicariously liable for the acts and grounds of those whose acts and grounds are not otherwise attributable. So the problem in Fessett was that whistleblowers were being victimised by colleagues who were not under a legal duty not to victimise them. They could not be said realistically to be acting on behalf of the employer, so that their actions could not be attributed to the employer under section 47B1. So if they'd been being victimised by their line manager, that may well have been different, but the introduction of the vicarious liability rule and section 47(1)(a) did not affect any changing of the attribution rules. So people who would have had their acts and grounds attributed to the employer prior to the vicarious liability amendment would still have their acts and grounds attributed to the employer. If they wouldn't have, well, they were now dealt with under section 47(1)(a). So the vicarious liability amendment simply doesn't touch upon the principal attribution question under 47(b), and it doesn't touch at all upon the attribution question under section 103(a). So the way to test it is not only is the approach that we're identifying not one that would make those amendments OTOs, because we're not dealing with people, not proposing a test that deals with people for whom vicarious liability would be in any way relevant. No
Mr. Jones, you and Mr. Gorton seem to be agreed, and no doubt if you're agreed, you're correct in saying that the new liability in section 47(b) 1A in respect of workers is a vicarious liability. But can you just help me about section 47(b) 1B, which we've got at 552, which says, as you know, where a worker is subjected to detriment, anything done as mentioned in subsection 1A, that thing is treated as also done by the worker's employer. Well, one might read that as not limited to vicarious liability, but to an attribution, if you see what I mean, Mr. Jones.
So sorry, 47...
B, 1B. Sorry, I was going a bit too fast.
Yeah, I don't think...
Where a worker is subjected to detriment by anything done in 1A, that thing is treated as also done by the worker's employer.
Yes, I agree.
Now, to my mind, that sounds rather like attribution and primary responsibility rather than vicarious responsibility. Because it's to be treated as done by the employer. Is that wrong?
I see the point. This is it's understood to be a vicarious liability.
Well, very well.
Responsibility. A similar but materially different approach is taken in discrimination cases, in that the order is reversed. So in discrimination cases, what happens is if I, for let's say a racial motivation, harass someone, I would treat them less favourably than I would treat one of their colleagues. That is deemed to be the employer's role, and then for reasons I've never managed to get to the bottom of, the employee that does it is treated as being vicariously liable for the employer's role. So it's a kind of weird reversal.
Oh.
But this is, as I understand it, this is intended to implement a similar, albeit differently structured, vicarious liability.
Very well.
Under the
Yes, the oddity, if it were pure attribution in 1B, would be the defence in 1D.
Yes.
Because if there was complete attribution, how could you have a 1D defence?
Yes, and indeed in 1B, one has to ask why they would simply say 1A rather than just saying where a worker is subjected to a detriment by, in fact, another worker or colleague. That wasn't just all swept up into a broader test for attribution under 47B. And they've done it separately under 1A for a reason. One reason is they want to make the reasonable steps defence available, which will not be available in a primary attribution case. But your point's a good one, which is that the language is odd because they want to deal with it by way of vicarious liability, which I think objectively they plainly do. They use language which would be equally apt in a primary attribution case.
Well, that's very charming of you, Mr. Jones. Thank you.
And we've stopped listening now.
I noticed the ears have stopped working.
But we will start again at 2:00.
Thank you.